Good afternoon, or good morning, or good evening, depending on where you are in the world. I want to thank you for joining our first Tech Safe Schools webinar. I am Doug Wood, the Associate Director of Grassroots Environmental Education. We are a nonprofit environmental health organization focusing on the health risks of common environmental exposures, and the Tech Safe Schools project is our latest initiative. Now, many of our programs focus on children, and that's for two reasons. First, we know that children are more vulnerable to many environmental hazards than adults. Their bodies are rapidly developing with immature detoxification and elimination systems. They have different behavior patterns than adults, and they have a longer lifespan during which to develop potentially serious health problems. Second, it's instinctive for parents to protect their children from harm. Once parents understand that a particular exposure could have lifelong health consequences, they become very interested in eliminating or mitigating that exposure. And so the fundamental purpose of the Tech Safe Schools project is to protect the health and safety of school children around the world, to prevent any child from an unnecessary and involuntary exposure that could negatively impact their health. The project has three pillars. First, the rapidly developing science around radio frequency, or RF radiation, demonstrating its ability to cause biological harm even at levels below current FCC human exposure guidelines. As you may be aware, the idea that harm from RF radiation is limited to the heating of human tissue, which has been the operating assumption for all regulation and legislation regarding wireless technology for more than 30 years, has been proven false by a large and growing body of scientific research, including the recent $30 million study by the National Toxicology Program of the National Institutes of Health. The second pillar is the legal responsibility of school administrators to exercise sufficient caution when it comes to exposing students, teachers, and staff to RF radiation, and the complete inadequacy of government safety guidelines that are based on the old heating of human tissue concept, and last updated in 1996. As you will hear today, reliance on these old standards, currently the subject of a major lawsuit, may not provide schools with immunity from legal action. And finally, there's a better way. Wired internet connections offer superior speed, economy, privacy, and security with no health risks whatsoever. Chromebooks and iPads are easily connected with simple adapters, and there are many other mitigation techniques you can find on the project website. I want to emphasize that our Tech Safe School program does not interfere in any way with the technology-based curriculum that schools are currently using. And now it is my great pleasure to introduce our lead panelist and moderator, Mr. Julian Gresser. Julian is an international public interest and environmental lawyer. He was twice visiting Mitsubishi professor at Harvard Law School, advisor to the US State Department, international organizations, leading companies, and environmental organizations. Julian has a deep domain expertise in the new field of EMF law and policy, and is the inventor of new approaches to resilient negotiation and resilient strategic alliances. He was instrumental in developing the concept of risk evaluation and the determination of compensation. Ladies and gentlemen, Mr. Julian Gresser.
Doug, thank you very much for your kind introduction. This is a very special program and opportunity, and I'm very much appreciative of the work that the organization has done in putting this all together. And I appreciate also the audience interest in this subject. So what I'll do is just set out briefly a number of principles and ways of thinking about our subject today that we will then elaborate throughout the program. First point to be made is that this is a new frontier of law, that it is a collective work in progress. However, there are strong legal precedents that can help school administrators understand exactly the situation and challenges they face and to guide them in making effective decisions. We see this also as a collaborative effort with our audience to explore and reason together. There's no easy pat solution to the issues, the scientific and legal issues that we will describe, but there is, we believe, a clear and effective decision toward thinking through the risks and to making what we believe is a wise and effective decision to protect our children, which is really the central purpose and mission of the program. So today, what I'd like to do is briefly hit upon some of the main themes, and then which we will elaborate in greater detail throughout the program. And the first is the question of responsibility, fiduciary responsibility and duty of care of school administrators. Usually the term fiduciary is used in the trust context where there is a financial asset. But here we're talking about the responsibilities for something far greater than a financial asset, responsibility for the care of our children. And clearly, school administrators are in the position of locus parentis toward school children. And associated with this critical role of our responsibilities. Now, some of these responsibilities, as we'll see, are based on federal law and state law and policy, because the policies of delivering a safe learning environment touch not only on the content of education, but also on the nature of the experience. And if the child's experience in schools is to be placed in jeopardy of health or psychological well-being, it raises serious questions of the responsibility of schools for allowing it. Now, public school children have a particular vulnerability because they're compelled to attend school. And so they really have no recourse or choice, and nor do the parents. And so exposing these children to high degrees of EMF radiation exposure raises serious questions. So what are the practical fiduciary responsibilities? Well, the most basic responsibility of a fiduciary is to be informed of what are the risks. If there are serious, significant risks, to ask those that are creating the risks, the telecom providers, the providers of these devices, to certify that they're safe. To be informed, to inform parents, so they can make the critical issue in law is a informed decision, informed consent. And to ask the developers of these devices to ensure that there is proper insurance, so that if children are harmed, that the financial burden and risk doesn't fall upon the parents or on the teachers. These are just basic concepts of fiduciary responsibility. And what we're saying is that the scientific evidence creates a high degree of vigilance and duty of care. As part of the fiduciary responsibility, school administrators have to be on an alert to these harms. And what we're suggesting, really, as a result of this program, that we will make available, not only in this program, but in the subsequent science program, the state-of-the-art of scientific studies that show clearly that there is a risk, a significant risk of harm. And once the administrators are so informed, then the fiduciary duty urges upon them a duty to find out more, to investigate, to be informed, to involve, if there's a medical officer in the schools, to have her or him, that doctor, alerted, to investigate, and to make available in a reasonable way the risks so that parents can make decisions on whether they want their children to be so exposed. So the principle of heightened vigilance, which is often referred to in Europe as the precautionary principle, applies directly here. And I think the only other introductory point I want to make is, once again, there is no insurance that is being offered to parents, to schools, for any of these damages. In fact, we cannot find one insurance company in the world that will underwrite the risks because they are simply deemed to be, from a business point of view, too high. And so schools need to know that they are starting to navigate into waters where businesses, the most sophisticated insurance companies will not underwrite the risks, and these risks are falling squarely on the schools, on parents, and their children. So this is a sort of overview. What we want to do today is to focus exactly where is the law today, without extenuating or amplifying it. What is the baseline? And then where, based on the law as we read it, both statutory law, federal law, state law, and practice, as well as tort law, in other words, judge-made law, where are we today? What is the baseline? And where do we see the trend moving, particularly in light of the history that we have of these large cases, whether they be asbestos or tobacco or lead in paint and in drinking water, and a host of other cases, Roundup and so forth. All of these toxic tort cases form a body of precedent which is described in a basic text, which we will make available to the participants, which goes into this in deep analytic fashion. But anyway, to begin, what we want to do is explore different aspects of this problem in order to set a baseline and then to reason together in what would be a practical course of action, a balanced course of action for school administrators. So our next panelist, our first panelist, is Robert Berg. I've had the privilege of meeting Robert in the course of work together here. He's a highly experienced class action lawyer. He's achieved hundreds of millions of dollars in recoveries for aggrieved consumers and investors during the past 30 years of his work in litigating complex class actions in federal and state courts nationwide. And he's represented plaintiffs in the consumer fraud, securities, antitrust cases. And he spent many years litigating these cases involving major telecommunication companies as well. So Robert is going to focus on the state and federal framework, statutory framework to protect our children. Robert, you have the floor.
Good afternoon and good morning, wherever you are across the country. I'm Robert Berg. I'm an attorney in New York. I've been practicing for 38 years, and for over 30 years, I've specialized in bringing large class actions on behalf of consumers and shareholders who've been defrauded by major corporations. Some of the largest settlements I've obtained have been against major telecommunications companies, including AT&T, Deutsche Telekom, which is T-Mobile's parent, and Sprint. More recently, I've become involved in lawsuits protecting people from unwanted exposure to wireless radiation transmitted by these telecommunication companies' facilities, including cell towers and the new kid in town, the small cell wireless facilities delivering 5G. Today, I want to impress upon you, and especially the school district superintendents and school administrators joining us, some of the legal risks you face if your school facilities are powerful Wi-Fi hotspots. As school administrators, your primary responsibility is to offer all your stakeholders, students, teachers, staff, and visitors, safe and secure facilities for educating the students. That means the facilities must be environmentally safe for the people who work and study there. Of course, over time, science develops and we learn things that we once thought were safe are actually toxic. I can think of no better example than asbestos. Early in my career, I actually represented an asbestos mining company on the defense side, and that ultimately turned me into a plaintiff's lawyer. I learned too many things defending these companies that bothered me, and I decided to go on the other side and sue companies for their bad actions. When I was a kid, asbestos was considered the miracle mineral. Asbestos is a commonly occurring natural mineral that has incredible fireproofing abilities. Its worldwide abundance made it very cheap. Its unique structure allowed it to be fabricated into an almost infinite number of products. It's very strong and durable. So up until the early 1970s, asbestos was a ubiquitous fireproofing material in buildings, ships, water pipes, roofing, tiles, brake lining, and many other products. Until the early 1970s, asbestos was used in virtually every school in this country, as many of you know too well. Asbestos was installed as pipe insulation, boiler installation, floor-to-ceiling tiles, and roofing materials in schools. Sadly, the world learned over the past decades that despite its miracle properties, asbestos is composed of sharp, microscopic fibers that break down and they get stuck in people's lungs, and they cause horrible cancers and asbestosis that develop over decades. So beginning in the 1970s, the terrible dangers of asbestos became more widely known, despite strong industry efforts to suppress that information. Asbestos eventually was largely banned, but the human toll has been and continues to be horrific, and the economic cost of remediation has been vast. As school supervisors, you well know when you renovate older school facilities that you have to remove any asbestos, and the process is very difficult, and the cost is tremendous. So what does asbestos have to do with Wi-Fi in your schools? Wireless radiation is another time bomb like asbestos, and you as responsible school administrators need to take steps now to minimize the risk of wireless radiation exposure. You can do so at minimal cost, and you have excellent alternatives. Like Doug said, and Julian, wired broadband, which is environmentally safe, is much faster and more secure. There are important lessons to be learned from the asbestos debacle. For schools, the cost of asbestos abatement and remediation have been enormous over the past decades. But more importantly, certain school staff, including janitors and those who work maintaining the physical plant, as well as teachers, have suffered and died from mesothelioma, other cancers, and asbestosis on account of their exposure to asbestos in the schools. So why risk having your teachers, your students, and your staff exposed unnecessarily to wireless radiation and the illnesses it may cause or exacerbate? Now, notably, every asbestos manufacturer, miner, and distributor has gone bankrupt, and all the insurers lost their shirts on account of asbestos, leaving today's victims with less access to recovery for their injuries. As medical evidence mounts about the dangers of wireless radiation exposure, the need to avoid another asbestos time bomb should be clear to school administrators. And here's another major issue to worry about, which Julian mentioned. The asbestos crisis was an utter catastrophe financially for the insurance industry. Many insurers went bust or lost a fortune because their liability policies did not exclude risks arising from asbestos. But commercial insurers are smart. They learned their lesson from the asbestos disaster very well. They are so worried about the risks of wireless radiation that they expressly exclude wireless radiation from every liability policy that they write. Even Lloyd's of London, which will underwrite virtually any risk, will not provide any coverage for the risks of wireless radiation. No insurer will. So your districts cannot obtain any liability coverage for the risks of wireless radiation. And the telecommunications companies, which are installing facilities on your school property or around your school property, they can provide no coverage either. They may provide you with a policy that says it's covering general liability risks, but there is an exclusion in those policies for wireless radiation. So if you're sued for any any wireless radiation exposure, and you're found liable for any claims for anyone who suffers injuries, you have no insurance coverage for those injuries. So the taxpayers ultimately will be paying the cost of that. And that's not all. If you have extensive Wi-Fi networks operating in your facilities, I believe you have certain legal obligations to certain students, teachers, and staff who can establish that they are disabled within the meaning of the Americans with Disabilities Act. Now, the telecommunications companies do a very good job running around telling everyone that their wireless equipment operates within FCC emissions guidelines, and that the FCC is the federal government's arbiter of the equipment safety. And therefore, the telecoms claim that their equipment has been shown to be safe by the federal government, and there's nothing to worry about. And then the telecoms tell you that you're not even allowed to question the safety of their equipment or the installation of their equipment because environmental or health concerns are preempted by the Telecommunications Act of 1996. Well, they're painting a misleading or an incomplete picture here. All that the Telecommunications Act of 1996 does is state that no state or local government or state or local law can raise environmental concerns about the location of any wireless facility that meets the FCC emissions guidelines. So the preemption is limited to the siting of the facility only, and it only preempts state or local law. So the preemption has nothing to do with other federal laws that may apply. And that's where the Americans with Disabilities Act applies to you. The Americans with Disabilities Act, along with the Fair Housing Amendment Act, imposes obligations upon a school to provide access to persons with disabilities and to make sure that the facilities are accessible to persons with disabilities if reasonable accommodations can be made. Now, certain persons are highly sensitive to wireless radiation. It's a medical condition known as electromagnetic hypersensitivity syndrome. So if a student or a teacher suffers from this medical condition, and it's a diagnosed medical condition, and there are physicians who specialize in this condition, and they come to the district and they say, I suffer from electromagnetic hypersensitivity syndrome, or the others use some different terms, and I cannot be exposed to wireless radiation, and therefore I need to be in a wireless-free classroom. The district has an obligation to make reasonable accommodation under the Americans with Disabilities Act. And otherwise, the district will face liability under the ADA, and you'll be responsible if the plaintiff wins a lawsuit, if they go that route, for attorney's fees and costs and possible damages. So there's a real risk to this. And this is a new avenue, a new legal frontier, as Julian said, and there have been recent court decisions that uphold the validity of this legal claim. The most important decision, which I'll talk about a little bit later in the program, is the case of G versus Fay School Inc. That's a federal court decision in Massachusetts in 2017, and it discusses in great detail why there is no preemption for this claim, and it sets forth the grounds on which a claim like this can go forward. And this presents a terrific risk, I think, for school administrators throughout the country, because there are a lot of people who do suffer from this condition, and they will be coming to the school administrators and saying, my kid cannot sit in the classroom and be exposed to wireless radiation all day, and you have to make accommodation for me and my child, and otherwise I'm going to bring a lawsuit. And you're going to ultimately incur, at a minimum, the legal expense of fighting that lawsuit, and I believe you're going to lose that lawsuit. And as Julian and Doug have said, there's an alternative for you, which is a reasonable alternative. Use wired internet broadband, which will provide you a safe alternative, and it's efficient and secure. There's another case that's very recent in the Court of Appeals in California, 2nd District, February of 2021, that a school teacher in Los Angeles, she also had a sensitivity to wireless radiation, and the school district in the building in which she was working installed a new Wi-Fi system at her school. It made her sick. She could not continue working at the school, and the school and she were not able to reach a reasonable accommodation on what to do, and she brought a lawsuit against the district, and that suit was upheld by the appellate court now in California, and it's proceeding against the district, and that's under state law in California. So you also have a state front to be worried about. So these are growing cases. It's a great source of liability for school districts, and it's an avoidable liability. That's all I'm going to say at the moment. I'll be proceeding later in the program.
Yeah, Robert, that was great. And I think your linking of the EMF field to the earlier asbestos cases is very reasonable. And there are many others, as I mentioned, areas of law that are germane to this new field. So our next panelist is Jim Turner. Jim is a principal at Swanken and Turner, one of the founders of Swanken and Turner. He represents businesses as well as individuals and consumer groups in a wide variety of regulatory matters concerning food, drug, health, environment, product safety. He's appeared before every major consumer regulatory agency, including the Food and Drug Administration, Environmental Protection Agency, Consumer Product Safety Commission, Federal Trade Commission, as well as the Department of Agriculture and the National Institutes of Health. Mr. Turner has been a lead attorney in successful petition in a number of other areas, particularly with the FDA, including the reckless acupuncture needles for he has them recognized for class 3, class 2 medical devices, permitting their legal importation and distribution. The key thing we would like you to focus on for the next 10 minutes, and I can perhaps add a little bit to your presentation, is the absence of an evidence-based federal standard for children, whether it be from the FCC or the FDA. We're operating in a no man's land no effective standard. And from your experience as one of the leading consumer advocate lawyers, what is your advice to school administrators in light of this present situation?
Yes, the legal framework of this battle goes on in a parallel or ancillary to the fundamental battle, fundamental issue, which is how do we ensure that children aren't harmed? All the work I've been doing from 1968 to the present is from the consumer point of view. My objective is to create the safest and most empowering and best place for individuals to be able to participate in whatever the situation is they're facing. When I started with Nader, he was doing cars at the time. We did a little bit on cars, but then I switched over to food, and we spent a lot of time over the last 50 years or so doing initiatives in food. That got me also into the drug area, and we've been doing things in drug. And then because of the Universal Product Code and coming in the early 1970s, I ended up being involved in the Consumer Communications, Telecommunications Act of 1976, and have been in that issue ever since. The situation we have right now that Julian laid out for schools is that the sellers of Wi-Fi services want to place their towers and place all of their systems and their tools and so forth everywhere they can. And so they're putting them into schools, churches, apartment buildings, wherever they can put them. And when the issue is raised that there may be some safety issues, they say a number of things. You've heard some of them from Robert Berg. And there are a number of other things that they say, all designed in that arena that's called the law. Think of it as kind of like mass, kind of a mass martial arts situation, extreme martial arts situation where they just, they'll kick, punch, whatever they can to keep the issue away from them. In this particular instance, what they have done at the FCC, which is a kind of unilaterally preempted control over these new emerging markets, they have said they are confident that the way they've set safety standards is proper because the FDA has supported them. The support from the FDA is a letter from an official at the FDA that never went through any of the processes that the law requires to establish a principle. The FDA has been involved in the telecommunications area ever since the early 90s. And in fact, there are some very minor safety guidelines on the cell phone. If you could figure out how to dig deep into your cell phone, you'll find a notice that says hold it a certain distance away from your head. Nobody really ever finds that. It's buried there. There were 2 lawsuits out in California that both of which said that information should be made available at the point of purchase, so you know before you buy the cell phone that you're supposed to do certain things, one of which is hold it away from your head. And the industry worked very, very hard to kill both of those. The lawsuits went in the direction of saying, yes, you have to show it. They appealed, they maneuvered, and so forth. There was never a ruling that said that the cities couldn't, it was Berkeley and San Francisco, that the cities couldn't require that. But as the battling went on in this, as I tried to say, mixed martial arts framework of the law world, they wore out the cities. They just basically stepped away from the issue. But at that time, the way that that particular warning got into the cell phones is that the FDA, up until the Telecommunications Act of 1997, the FDA was in charge of that radiation standard, and they were holding a joint committees with other agencies to set standards. And at a certain point, the industry was being very recalcitrant, and the FDA said, if you don't put standards on here, we're gonna just do a recall on all cell phones. At that point, two things happened. One, they put the warnings in the cell phones, and two, they worked really hard to get the Telecommunications Act passed that took away basically the formal FDA authority on that issue. They still have a lot of leverage and a lot of responsibility. And what's interesting is that the FCC has drawn them into it because the head of devices regulation at FDA did write a letter saying that he thought that the FCC position was sound. And even though the FDA had commissioned a $30 million study that showed cancer being caused in animals by EMF, he felt that since it was only animals, they hadn't conclusively proven that it would happen in humans, and therefore the FCC could go forward with its standard. The standard itself is scientifically severely limited for a number of reasons, but the argument that we are planning to make at FDA is not that the standard is a bad standard. The argument we're making at the FDA is that they did not go through the proper procedures to establish the standard that the FCC is relying on. The problem that the schools face is that, and incidentally, it's not only schools, but it's also people who are managing apartment buildings, condominiums, office buildings, churches, fire stations, and so forth across the country. All of those people are facing the same problem. It's very important in schools because of the children in the schools in particular. But the problem is that when this battle is fought out, ultimately the FCC and the FDA are not going to be able to stand behind the standard they have legally. The way that the companies are playing this is that will be, if we just walk through our legal processes, that'll be 2, 4, 8, 10 years from now, and they can, and particularly the managers in charge now, can weather that storm and get their money out and leave. But at some point, the landlords and the school administrators and so forth are going to have to face the consequences of the decision that the FCC has made. Our strategy is to argue that the FDA has not, in fact, formally adopted a standard, and therefore, when the FCC says to a judge, we have a standard that the FDA has backed, we can go in and say, wait a minute, judge, this is what they did. This is not following the proper procedures to create the proper standard. And it's our judgment at the moment that in that legal battle that we will get judges to say, we think that the FDA better figure out how to do this rather than just let the agency at the FCC rely on that. In all of that, it's very important to understand that we're working hard to create a framework in which what the rules the government adopts helps the students in the schools. But that will take time and battling. And at the end of the story, it's quite possible that the schools will be held responsible for not having done what they should have done. Issue of whether they're responsible or not will be a separate litigated issue. What I can say right now is that we're doing the same sort of thing with landlords and other people who are in the same position, and they are now beginning to do things such as a major landlord here in Washington owns many buildings, who has asked T-Mobile to stop putting up any new towers on their buildings until after the COVID-19 problem is over. Now, the idea of asking them to wait is very valuable to us because that buys time in the legal battle. So, Julian, I think I've covered everything I intended to cover. Do you want to point me in something else I should address, or do you want to take up a couple minutes here?
Just a few points to be added. Children that have pre-existing serious conditions, a child could be autistic, could be diabetic, could have cardiac issues, could be prone to seizures, and so forth, or have various behavioral challenges. From the medical evidence that we will explore in the next seminar, every one of these children is placed in higher risk by being exposed to EMF overexposure and radiation. And therefore, as Robert points out, have legal rights, as do their parents, under the Disabilities and Fair Housing Act, to ask for a reasonable accommodation. The area of tort law and damage claims is a new frontier, and will most likely follow, as in other areas, from these statutory rights and cases. But the law is rapidly evolving, and as Jim points out, we're working at several levels here, and one is at the agency level to try to encourage science-based standards, both by the FCC and by the FDA. And this is coming, and it's coming rapidly. So, Jim, I think we should.
Let me make one. I just want to make one other quick point, Julian, that you touched on, but I want to reinforce it, especially for this audience. In every single consumer issue, what emerges is that there is an initial group of people who are susceptible to the problem that's being addressed, whatever it is. It can be a particular food additive, a drug side effect, EMF, whatever the issue is. Somebody begins to be the first one injured, and then that number increases, and that increases until it is identified as a threat to the community. And the problem that we face from the consumer side is that even one child harmed is a problem that needs to be addressed, even though the system isn't designed to consider that a significant problem. The system's idea is really, they look at what is the minimum number of damage, what's the minimum number of damaged children that we can take on in the society and consider it to still be justified. The FDA has a standard that if 1 in a million people dies from cancer in a year, that's an unsafe chemical. If more than 1 in a million, if 1 in a million dies, it's safe. Now, part of our argument is that when you have people who are having measurable problems, you are actually finding the tip of the iceberg of the people who have problems that are not measurable. In our issue on sweeteners, kids that were taking NutraSweet, Ascertain, had their ability to swing a baseball bat reduced by the amount that it took to hit a fastball versus not hitting a fastball. That's a study that's published, and it's there. That doesn't show up anywhere in who gets to be compensated, who is harmed, but each kid is being affected in some way by these kinds of issues, such as the EMF. And I just want to make clear that the legal battle is, how many kids are we going to allow to be harmed before we take action? And our position is we should have standards that say no children should be harmed, and we can make standards like that. That's what these alternatives we're talking about are lent to do. Now, we may still have some children harmed, but we'll work to get zero tolerance of that kind of harm. And there are ways of doing that.
Great. Okay. Well, so our next speaker, thank you very much, Jim. I think that was really important to provide the consumer perspective on this. Our next panelist is Andrew Campanelli, who is really perhaps the nation's top litigator in the area on this focused new field of cell towers. He began his legal career as a litigator in 1992, and he's handled well over 7,000 civil cases and litigated over 1,000 of these cases to their conclusion, both the federal and state courts. Andrew, if you could just take literally 5 minutes, because we want to give the audience ample time to pose questions for us, difficult questions. But I'd like you to just focus on the single concern, based on your experience, that school administrators will have, that they really don't have authority or an ambit of legal basis to object, that their hands are tied, and to focus particularly on your work under the Americans with Disabilities Act. And what is the fundamental lesson you can extract from your work with these thousands of these cases that can be helpful to school administrators? Because that's actually what we're trying to do here, is to work with the school administrators and the communities here to help them affect what we think will be a beneficial change. So if you could just reserve your comments for 5 minutes, I can wrap it up in 5 minutes so we can turn it over to the audience.
Okay. The distinction that school districts have as opposed to local governments is that school districts are not technically acting in a regulatory capacity when it comes to the placement of wireless facilities. There are situations where schools will lease space on their property to allow a carrier or a site developer to install a wireless facility. But when they do that, they're acting what's called a proprietary capacity. There was an interesting case involving Sprint, where Sprint had signed a lease to put a cell tower on top of a school. And the school district put into the lease a limit on the level of RF radiation that the facility would be permitted to emit. After the lease was executed and the tower was built, Sprint went back and said, well, we want to increase the power output above the limits set forth in the lease. And the school district said no. They brought a federal lawsuit, and a court said that the terms of the lease are not preempted by the FCC or the Telecommunications Act, because when a school district leases space on a property, it acts in a proprietary capacity, not a regulatory capacity. The reason I'm telling you about this case is school districts have the power to lease space on their property for wireless facilities. It's up to them. It's their choice. They don't have to let wireless facilities in. They're just like any other property owner. And if and to the extent they do want to let somebody bring a wireless facility in, then it's up to them to decide where and what level of power they're going to allow it to emit. Now, Julian had mentioned the ADA and the FHAA. We have arguments we're filed in federal court as we speak, claiming that to the extent that someone may feel that they have RF sensitivity or are EMS sensitive, theoretically, that person would be disabled within the meaning of the ADA or handicapped within the meaning of the FHAA. Now, why is that relevant? Schools have a unique position with regard to children. Their principal purpose is not merely to teach, but to provide children with a safe learning environment. And that, of course, would include an obligation on the part of the school to abstain from exposing them to anything that might be harmful to them. When you think in terms of RF radiation, the problem for schools is they have a captive audience. Children are required by law to attend public school. Well, if you have a child who is EMS sensitive, you are forcing them to sit in a school, in a classroom, theoretically, 8 hours a day, 5 days a week, the entire school year, while being bombarded by RF radiation, which may have an adverse impact on their health. This, in my view, would enable them to serve a demand upon the school district and any provider as a public utility for what's called a reasonable accommodation. Under federal law, if they are in fact disabled under the ADA, theoretically they're entitled to demand a reasonable accommodation, which would mean whatever reasonable accommodation could be made to abstain from exposing them to RF radiation that might cause them adverse health impacts. As we speak, there's federal litigation pending right now. There was a case in Massachusetts where a child was recognized as having a sensitivity, and the federal court acknowledged that RF emissions could subject someone to a disability that would be covered by the ADA. But in that case, the litigants could not come up with a reasonable accommodation. So the matter is really on the cusp of the law. The case that I have pending now is in the Northern District of California. I am eager to see the outcome and what determination is made by a federal judge. And specifically, we're asking the federal judge to rule basically that the Telecommunications Act does in no way, shape, or form preempt an individual from asserting their rights under the ADA to the extent they need a reasonable accommodation to seek removal of a wireless facility, which would expose them to RF emissions, which would adversely impact their health.
Andrew, that's terrific. Let's move on to Mark Pollack. So Mark Pollack is an attorney in the Bay Area. He has 42 years of practice. He was the first full-time environmental prosecuting attorney in California, working at the Napa County and Solano County District Attorney's offices. Mark's advised public utilities and entities in his capacity as an environmental prosecutor. He's now a senior partner in his own law firm of Pollack and James on environmental law, and he resides in Napa, California. Mark, what I'd like you to do is to focus on the regulatory level at the local level, local ordinances, independence of schools that overlaps with regulations, and so forth, to really bring home the point that we hear in the context of local authorities. Our hands are tied. I made the point a few minutes ago, but I think having your expertise to illuminate that point would be really useful. Mark, the floor is yours.
Thank you, Julian. So I'm going to dovetail my response with what Julian just talked about and what Robert talked about concerning liability insurance, and how the requirement for liability insurance provides additional leverage for school administrators to create safe environments within the classroom and on school grounds. As a background, some of you may not know that California has a very interesting statute on its books called the Safe Drinking Toxic Enforcement Act of 1986. And what this statute uniquely does in California is it requires California to keep a list of all chemicals known to cause cancer to the state of California. And then if an individual is exposing someone to one of these chemicals, such as benzene, which is a component of gasoline, known to cause cancer, then the person doing the exposing is required to give a clear and reasonable warning to the person being exposed. The purpose of the act is not to prevent exposure, but to provide adequate information to the person being exposed so that they can avoid the exposure. The act provides us, in a sense, with a matrix, because in the school context, in light of the fiduciary duty obligating the care for children by school administrators, staff, and teachers, once the administration has knowledge that they are exposing young people who are susceptible to these radiation waves, they have a moral obligation, a fiduciary obligation to warn and to provide a clear and reasonable warning. As Robert referenced in his comments, there is a standard exclusion that you will find in any general liability policy of insurance. So let me put this in context. If the school district allows a company like Verizon Wireless to come in and place EMF technology in the classroom, or worse, to lease school grounds to put up a cell tower on the school property, there's nothing to prevent that school district from requiring insurance that covers exposure to EMF. The problem for the telecom company is that from Lloyd's of London on down through the chain, no one will insure EMF exposure. What they do is they attach a rider to the policy called a pollution exclusion. And that pollution exclusion document has language that describes EMF as a pollutant, quote unquote. So at this point, what the municipality or the school district should do is it should require an actual copy of the policy of insurance so that it can see two things. Number one, it should ascertain whether or not there's a pollution exclusion, and if there is, then it should deem the policy of insurance inadequate. This may be a legal basis for voiding the lease and terminating the lease and causing removal of a tower. Additionally, as Julian and Robert have both pointed out, there is a way to provide internet access within the classroom without EMF exposure, and that's wiring the workplace, wiring the schoolroom. So the school district can say to the telecom company, if you can't insure, then you can't irradiate. You cannot expose people to EMF radiation if you can't insure for it. Now, the telecom company may come back to you and say, well, we'll self-insure. we will self-insure. We can't buy insurance, but we're big, we're rich, we've got the money, we'll cover. So there's no liability for you, school district or district administrator. So I'm going to tell you that this is a shell game. And I'm going to give you an example. As an example, in Napa, GTE MobileNet of California does business as Verizon Wireless. And the policy of insurance that will be produced, or the so-called self-insurance, will be in the name of Verizon Wireless. And Verizon Wireless is a DBA for GTE MobileNet of California. Now, if you go to the Secretary of State's website, you will find that GTE MobileNet of California is a limited liability company registered with the state. The last registration was in 2008. On that registration certificate at the bottom, it shows the general partner for GTE MobileNet of California to be a company called Selco Partnership out of New Jersey. Selco is not licensed to do business in the state of California. I have a document here, which is 8 pages. This document lists all the subsidiaries of Selco Partnership on 8 pages in every state of the union. And you will find that on this document, Selco's subsidiaries list 200 of them doing business as Verizon Wireless. If you contact us on the website and send me your email, I'll scan this document and send it to you. You can provide this document to your school district, to your boards, and when a self-insurance certificate is produced under the name of Verizon Wireless, it's essentially useless because that name is shared by 200 different entities. So you don't even know who you're dealing with in a legal context. And when the school district gets sued for EMF exposure, it's like having no coverage at all. So the school district needs to demand actual insurance, or that an actual licensed entity, an entity registered with the state in which you are located, is on the certificate of insurance so that you actually do have insurance. Thank you very much.
Well, thank you. So what I'd like to do for our last part of the program to have 2 parts to it, but under the title, Bringing the Winning Case. And Mark started already to lay out some of the practical to-dos that will set up the winning case. But first, as part of it, I want to come back to the legal rights that a school has, particularly under the ADA and the Fair Housing Amendments Act, of which Andrew Campanelli is a grandmaster. Andrew, if you could just take literally 5 minutes, because we want to give the audience ample time to pose questions for us, difficult questions. But I'd like you to just focus on the single concern, based on your experience, that school administrators will have, that they really don't have authority or an ambit of legal basis to object, that their hands are tied, and to focus particularly on your work under the Americans with Disabilities Act. And what is the fundamental lesson you can extract from your work with these thousands of these cases that can be helpful to school administrators? Because that's actually what we're trying to do here, is to work with the school administrators and the communities here to help them affect what we think will be a beneficial change. So if you could just reserve your comments for 5 minutes, I can wrap it up in 5 minutes and we can turn it over to the audience.
Okay. Well, first, the distinction that school districts have as opposed to local governments is that school districts are not technically acting in a regulatory capacity when it comes to the placement of wireless facilities. There are situations where schools will lease space on their property to allow a carrier or site developer to install a wireless facility. But when they do that, they're acting what's called a proprietary capacity. There was an interesting case involving Sprint, where Sprint had signed a lease to put a cell tower on top of a school. And the school district put into the lease a limit on the level of RF radiation that the facility would be permitted to emit. After the lease was executed and the tower was built, Sprint went back and said, well, we want to increase the power output above the limits set forth in the lease. And the school district said no. They brought a federal lawsuit, and a court said that the terms of the lease are not preempted by the FCC or the Telecommunications Act, because when a school district leases space on a property, it acts in a proprietary capacity, not a regulatory capacity. The reason I'm telling you about this case is school districts have the power to lease space on their property for wireless facilities. It's up to them. It's their choice. They don't have to let wireless facilities in. They're just like any other property owner. And if and to the extent they do want to let somebody bring a wireless facility in, then it's up to them to decide where and what level of power they're going to allow it to emit. Now, Julian had mentioned the ADA and the FHAA. We have arguments were filed in federal court as we speak, claiming that to the extent that someone may feel that they have RF sensitivity or are EMS sensitive, theoretically, that person would be disabled within the meaning of the ADA, or handicapped within the meaning of the FHAA. Now, why is that relevant? Schools have a unique position with regard to children. Their principal purpose is not merely to teach, but to provide children with a safe learning environment. And that, of course, would include an obligation on the part of the school to abstain from exposing them to anything that might be harmful to them. When you think in terms of RF radiation, the problem for schools is they have a captive audience. Children are required by law to attend public school. Well, if you have a child who is EMS sensitive, you are forcing them to sit in a school, in a classroom, theoretically, 8 hours a day, 5 days a week, the entire school year, while being bombarded by RF radiation, which may have an adverse impact on their health. This, in my view, would enable them to serve a demand upon the school district and any provider as a public utility for what's called a reasonable accommodation. Under federal law, if they are in fact disabled under the ADA, theoretically they're entitled to demand a reasonable accommodation, which would mean whatever reasonable accommodation could be made to abstain from exposing them to RF radiation that might cause them adverse health impacts. As we speak, there's federal litigation pending right now. There was a case in Massachusetts where a child was recognized as having a sensitivity, and the federal court acknowledged that RF emissions could subject someone to a disability that would be covered by the ADA. But in that case, the litigants could not come up with a reasonable accommodation. So the matter is really on the cusp of the law. The case that I have pending now is in the Northern District of California. I am eager to see the outcome and what determination is made by a federal judge. And specifically, we're asking the federal judge to rule basically that the Telecommunications Act does in no way, shape, or form preempt an individual from asserting their rights under the ADA to the extent they need a reasonable accommodation to seek removal of a wireless facility, which would expose them to RF emissions, which would adversely impact their health. So I tried to keep it under 5 minutes, Julian.
Yeah, Andrew, that's terrific. What I want to do is now, for about 3 minutes, pull all the threads together, and then we'll open up to the audience. And to do the pulling the threads together in a very practical set of to-dos that a school administrator and the community can consider, which will not only accomplish the goal of delivering a safe learning environment, but tee up what we call the winning case. So the first thing, which is pretty clear from what we've all said, since this is not insured, the risks are not insured or insurable, that the school should ask the device providers as well as the tower installers to certify the safety of their products. That's a reasonable request, and to say that the consent of the parents and of the school community is conditioned on that kind of a representation and certification. The second is to bring in, if there is a concern that some of the children are reporting that they're perhaps getting dizzy or having not sleeping well, or having some of these symptoms that come up all the time, to bring in a building biologist and to get a survey of the level of EMF exposure for the school. In the case of Tahoe, for example, we know that there are 2 macro towers right on the playing field of the schools. It's near the children's dormitory. There ought to be immediately a building biologist who's brought in so the school community can know the levels of radiation, not just at a single reading, but cumulatively and aggregatively. So that is a clear to-do. It's necessary as a precautionary measure. It's also necessary in building the case. The next is to do a survey of whether some of the kids are starting to report, and the teachers, symptoms. We have, as part of what we call the basic text for this course, a series of documents, one an amicus brief that we filed in the Children's Health Defense Environmental Health Trust case against the FCC on behalf of the Building Biology Institute. And there are declarations in this amicus of parents on behalf of their children, and you will hear the voice of suffering, and you will also, of these children and their parents, in great detail, and the symptoms that come up repeat. So this is not idiosyncratic, it's actually systemic, that these same symptoms come up. And the health, if you have a health officer in your school, it behooves her or him to do a survey. What is the level of exposure? What are the symptoms that are being reported? And to do it in a spirit, not of fear, but inquiry, because often it comes up, there's a fear of retaliation here. Teachers have to feel confident that they can participate in this kind of a survey without being discriminated against or retaliated against, as was present in the Brown versus Los Angeles Unified School District case. And then to draw upon the advice of your local council. We're not offering legal advice in this program. This is purely educational, and that should be stated at the beginning, but this is we're not charging anything. This is really just to help educate and open a dialogue. But you do have recourse to your council, that your council can review our basic academic educational document and derive a specific legal opinion, which then you can use to place the product providers and the telecom companies on notice that there has not been informed consent, that you are deeply concerned about the risks that children are already experiencing, in some cases harms, and that you're asking, as Andrew pointed out, for a reasonable accommodation to address these harms. Not only are these wise precautions that you can immediately adopt, but they set up what we call the winning case, because if the telecom companies and the product providers, the router providers, the computer providers, the cell phone providers ignore all of this, they are on full notice. And as we've said, compliance with the regulatory standard does not shield against tort liability. And so what we want to convey here is that this is an emerging area of law. Momentum is building. There are ample precedents. The law is on your side. And what we're offering here is a reasonable accommodation and a path of balance. The economic cost of shifting in a way that delivers true, safe learning environments to children are extremely modest against the potential liability that you will face if you don't at least give some reasonable attention to what we're laid out in this program. So we're a little bit beyond schedule, but I do hope that this has been informative. And now the real inquiry begins with your questions. So we bring our whole panel together, and we're at your disposal, and we want to reason together to find this path of balance. So thank you very much for your attention. Doug, I'll give it back to you.
Thank you, Julian, and thank you to our whole panel. You know, this has really been great, really terrific information, and we are very appreciative. We do have a lot of questions. One of the first questions we got is whether or not there's an opportunity to pursue a case using criminal law as well as civil law. So I think we have some non-lawyers on the.
Okay, I can take a shot at that,
Sure.
because we have looked at this in great depth. And here is the what I think is at least my thoughts on the subject, and I open it to the panel as well. You have to understand there's a difference between what is on a statute and what in practical terms a prosecutor's office will undertake. Ray Broomhall in Australia has been a pioneer of using criminal law of assault as a basis for warnings to cell tower installers and other words. And he points out to us that there is a case now working its way which a court may actually recognize a criminal assault for exposing children and parents to this level of acknowledged admission, penetration of. And I will point out this is not only in the regulatory standard of the United States, it is what the industry association called ICNIRP has acknowledged. Now, many states, such as California, have penal code sections right there in the penal code about child endangerment, of assault on disabled people. And this is not just a West Coast phenomenon. You will find similar provisions on the East Coast and the central part of the United States. So clearly on the books, we are looking at here what could be argued as a criminal assault. But this is such a new frontier. And for understaffed prosecutorial offices, it looks far-fetched. At least that's been our assessment. Now, if a state were to pass a statute that recognized it beyond sort of making it specific to schools, that would be perhaps another thing. But it's a legal area that is certainly uncertain. As we pointed out, there are sufficient challenges on the civil side where the burden of proof is much less stringent. So it's an outlier, certainly in you, notwithstanding that you could say it's on the books. And the fact that it would be done against the consent of parents for children, as Andrew points out, who are required in public schools to attend and be exposed for 8 hours a day. Certainly emotionally could understand this, but technically from a legal point of view, we cannot point to any case in the United States where a prosecutor is brought under theory of assault or endangerment, a link to EMFs. But other panelists may have further comments.
If you look at the asbestos situation, 30 years ago, 40 years ago, if there was asbestos being present in the school building and collapsing from the ceiling, no one would have said anything. They'd bring a janitor out and he would sweep it up and throw it in the garbage. Today, if that happened, you'd go to jail if that was done. So this is an emerging area. If the science develops as such, you may see that in the future, but right now, I think Julian's completely correct. You're not going to get a prosecutor to bring a criminal assault case, but things develop over time as we learn more and as the science develops.
I have a question that's come in about small cell placements. If the small cell is in a public right-of-way and that public right-of-way is on school grounds, what happens? Can the school fight back against that placement?
Andrew?
That's a loaded question. It merges a whole bunch of issues. It depends upon what state you're in. It depends upon the definition of what's a right-of-way under state law. It depends upon what your local zoning code provides. The wireless industry is trying to use a recent interpretive order of the FCC, and more specifically the order of September 2018, to claim that to the extent that a small cell or DOS node is situated in a public right-of-way, the ability of local governments to regulate them is far more limited than it has been for the past 24 years. That issue is being battled. But while it's being battled, the wireless industry has been inducing state governments to enact state legislation which strip the powers of local governments to regulate the placement of facilities in what they call public rights of way. But they're using what I call hoodwink ordinances, because their definition of what constitutes a small cell or a public right of way is ridiculous. They use definitions which means just the opposite. So for example, in a typical state statute, when it says you can't regulate a small facility, it in no way, shape, or form limits it to actually facilities which are small in size, but the definition includes 200-foot cell towers. And as far as what constitutes a public right of way, it would include pretty much anything. It'll include all roads, sidewalks, areas near roads or sidewalks, even private properties that have easements on them. If anybody has electric or telephone wire running to their home, there's an easement. And that means that they can claim that part of your private property is in the right of way, and they can come and put a 150-foot cell tower on your front lawn. And if you think that sounds ridiculous, I'm dealing with it every day across the entire United States. So the short answer is, do they have the power to control the placement of small cells and DOS nodes on a public right of way on school grounds? The answer is, it depends. It depends on if a state law has been adopted in your state, and there's 23 states that have them now, what that state law says, and what your local zoning code says, as well as what decisions are out there from the Circuit Court of Appeals that covers your circuit.
Mhm.
So each one of these gets looked at on a case-by-case basis.
Great, thank you. Anybody else want to comment on that before we turn to another question? I've got a question. When Julian suggests that schools request their providers provide a certification of safety, is that a specific standard to the certification, or is it open to subjective interpretation and response by each provider?
Is that aimed at anybody specifically? Okay, I'll take a shot at this one.
Sure.
Go ahead.
When you're asking for a certification of this type, the reason you ask for a certification is that it's a representation which theoretically the school district is now going to rely upon. So if someone gives a certification saying this equipment is safe, i.e., it's not going to expose students to dangerous levels of RF radiation that may harm them, what is the purpose of it? The purpose of it is to enable the school district to rely upon that, so that if in fact someone is injured because it's not safe, theoretically the school or the injured student would be able to go after, i.e. sue, the company that gave the false certification. The type of certification and whether or not it's good enough to serve as a basis for liability to enable a person who gets injured to sue the company would depend upon state law. When is a representation the type that reliance upon it is reasonable, and if someone falsely certifies a statement such as that, can, under the state law, can an injured party sue them for the false certification? And that varies from state to state.
Yeah, this certification request is designed to plug or span the gap in the advertising of the device manufacturers and cell tower companies. They've made every effort, in some sense, in the marketing departments to convey that this is ideal for school environments and across the country, but have not, they stay just an inch or two away from actually saying that the products and the towers are safe. In other words, they've been probably, and no doubt at the advice of counsel, not made that bold claim, although it is clearly implicit in their advertising material. And what we're trying to do is say, call the issue for what it is, to say you are effectively representing to our school that these children are not going to be injured. We just want you to put your writing where your mouth is and to confirm it. And that will set up what we're calling the winning case. Now, if they refuse to do it, as they have every right to do, well, the school now has even more data to make what we're calling a wise decision.
Yeah. We're getting a lot of questions about the ADA. I think a lot of people that are logged on today are kind of hearing about the ADA as for the first time in terms of pushing back against wireless radiation. So I have two kind of related questions. One is, what kind of, what is required to assert a condition that needs to be addressed by the ADA? And then what kind of guidelines have to be recognized when the case, when and if the case goes to court? Does it have to be only established government guidelines, or can it be, some of this emerging science, which is very clear about the danger that radiation poses?
Well, Andrew, excuse me, this is one that is right up your alley. But
Yeah.
Let me just simply say that there is now a developing body of physicians across the country who are trained and have really looked into the literature of clinical electromagnetics. There have been two major conferences now in one last year and just this last one, last in January, where, I don't know, several hundred doctors across the country in many different specialties, from pediatricians to psychiatrists to oncologists and so forth, have gone through a formal program of beginning to to familiarize themselves in their disciplines about this new area of medicine, just as is a new area of law, a new area of medicine. And these doctors are available as experts to provide medical opinions on the health challenges, not only in terms of EHS, but on the earlier point I made, for all these standard medical fields are going to be arguably raise even more difficult problems now by exposure to EMFs. And this sets up the ADA case that Andrew will now describe.
So every day my phone rings and people are asking for help because there's a wireless facility that's exposing them to radiation that's adversely impacting their health. Under the ADA, if someone is disabled, they have a right to demand of a local government, or in some cases, even a public utility, or someone who maintains a common area, for something called a reasonable accommodation. Under the ADA, that requires the government to then have an ADA compliance officer make two types of determinations. Number one, is the person seeking a reasonable accommodation disabled within the meaning of the ADA and thus entitled to a reasonable accommodation? And two, what is that reasonable accommodation? So I am asserting the position in litigation in federal court that EMS sensitivity is in fact a disability under the ADA, and it's also a handicap under the FHAA. So to the extent that a wireless facility is built so close to your home, and you are EMS sensitive or not EMS sensitive, but the facility is emitting radiation into your home at such levels that you are suffering significant adverse health impacts, that you have the right to demand a reasonable accommodation from both the municipality and the carrier to afford a reasonable accommodation, the only logical one of which, of course, would be to remove the facility to a sufficiently safe distance that it no longer impedes your ability to enjoy the use of your home. As far as when someone might have a viable case, there are two criteria that I essentially look at to ascertain if you have a viable case. Number one is the proximity of the facility. The closer the proximity to your home, the stronger the possibility is that you may be able to assert a viable claim. If it's 20 feet from your bedroom window, that's pretty close. If it's 5 miles away, it's not. But the second issue is of equal importance, that is some form of professional opinion of proximate cause, meaning, do you have a physician who knows your medical history, they're your general physician, and are they willing to give a professional opinion letter saying that in their medical opinion, in their professional opinion, they believe that there is a causal connection between the radiation emissions you're being exposed to and the adverse health symptoms you have experienced and related to them. If and only if you can come up with those two things, I think you can then assert a viable claim.
Can I just jump in and say,
Sure.
I think actually it's a little bit easier that we don't have to prove in a judicial way that X caused Y, that EFA caused, but rather that given your condition to be continuously exposed, is there a significant basis for aggravation of your condition? That itself, I think, would be established an ADA claim. Not that they have to prove that the child's leukemia was actually caused by the exposure, but rather a child, as we have some cases, somebody has a multiple myeloma, and they're going to go back and be exposed continuously to this level of radiation documented by the building biologist. That itself, that additional level of risk would be a basis for a reasonable accommodation.
That's true, Julian. And just so I'm clear, I'm not asking federal judges to make determinations, factual determinations, as to whether or not someone is in fact disabled within the meaning of the ADA because their health is adversely impacted by exposure to RF radiation. What I'm asking federal judges to determine is that rights to seek relief under the ADA is not preempted under the Telecommunications Act of 1996. And I'm simply asking the judge to direct local governments that when they receive a demand for reasonable accommodation, that they entertain that demand just like any other demand for a reasonable accommodation under the ADA. So now each local government in each specific case would have to make an assessment. Someone would have to examine the evidence and make a determination if someone is in fact being adversely impacted by the radiation, because federal judges are not going to do it, and I wouldn't ask them to.
And the decision in the Fay School case in Massachusetts came straight, I mean, hits the nail on the head here. It says there is no preemption for an ADA claim. And
Yep.
I think the reasoning there is really very, very strong. I think it's completely correct. And I think other federal judges will rule similarly. And it's great that Andres' case in Northern District of California, hopefully that judge will rule the same. And we have other cases pending which are going to seek the same determination. And it's a real risk for the school districts in particular, because there are a lot of kids in the schools that have medical conditions that will be exacerbated by Wi-Fi and radiation. And they're going to be coming to you and seeking accommodations, and you're going to have to deal with that.
Great, thank you for those clarifications and answers. That's terrific. I have another set of questions related to informed, as you know, part of the point of the Tech Safe Schools is to inform, kind of in a formal way, inform the schools of this issue. A couple of questions have come up. Number one, at what point does that obligate the school system to inform teachers, especially if the teachers have a union resolution calling for a safe technology to be used in classrooms? The other is, at what point is the school obligated to inform parents that there's a certain level of RF radiation to which their children are going to be exposed in classrooms? So that's...
That is precisely the question I was trying to tee up, and I'm really glad that the questioner asked it. That what we're saying is that as openers, the most basic duty of a fiduciary, and that was the way we opened the program, school administrators are in a fiduciary relationship to the children and to the teachers and so forth. The most basic duty is to begin to be informed, to inform themselves about the science, about the law, about the alternatives. And what we're saying is that thanks to Tech Safe Schools, we've packaged it all together. So really what we're saying is if you read this material, including the basic text, and attend the next seminar on the science, where you've gotten some of the top people in the world to address these issues, the natural next thing is to, okay, go deeper, read some of the studies, inform yourself, but they will inevitably compel the next set of actions, which is to inform the community, meaning the school community, meaning the teachers unions, and the parents. That's the second duty. The third, you could argue, is to at least have a hearing with them, and if they if they withdraw their consent or refuse to give their explicit consent, that raises a really tough legal question for the school administrators. Can they really ignore an informed refusal to allow children, in the case of teachers, many of whom have sensibility, special sensitivities, such as in Brown, can they just override it and say, no, your children have to be in the school and they have to be irradiated? That is a really tough decision. We're trying to make it an easy decision, but I think for schools this is such a shift in thinking, I think we have to be somewhat patient to work together with administrators who are in this dilemma and just continue in a compassionate way to provide the data.
Anybody else want to weigh in on that threshold of advice, which would trigger a responsibility?
Well, I think the responsibility is there, and to be an ostrich is not the right approach, and the legal liability is enormous. You just cannot stick your head in the sand, and you have to disclose what you know and face the risks and deal with them. We've learned time and time again, if you ignore them, the cost becomes greater and greater down the road. So you got to deal with it.
Great. Okay, we are pretty much out of time. We're at the end of our first Tech Safe Schools webinar. I want to express my real thanks to Julian, Andrew, Mark, Robert, Jim, everybody who was part of our panel today. This was really terrific. We appreciate your information. We know how busy you are, and we appreciate your being on. Also want to give a shout out to the people who have made this possible. Ben Levi, who has been managing the technical aspects of this. Thank you, Ben, for your help. And also from our own staff, our boss, Patty Wood, who's the executive director of Grassroots, Zoe Berg, Ali Straub, Faye Samus, Cheryl Matthews. Thank you all for what you are doing. And especially thanks to you who signed on today to listen to this webinar. We hope you found it interesting and informative. This will not be the last of our legal roundtables, I'm sure. We're just kind of starting on our outreach with the tech-safe schools, and we expect to get a lot more interest as the days and weeks go on. So thank you for your support. Please pass the information on to anybody that you know who has children in school, or to any school officials you know. Again, thank you for your participation and your interest in the subject. We look forward to seeing you on Thursday. We're going to have the second webinar, and that one will be about the science and medical kind of footing for the tech-safe schools. So it should be really interesting. We have some great speakers. We hope to see you then. Thank you so much, and goodbye for now.